Welcome back to the Daily Drum on WHUR 96.3 HD2 and Sirius XM channel 141. I'm Harold Fisher. It's not just for the old and the rich. Estate planning should be something on all of our must-do list. Well, tonight we'll tell you how to get started and why failing to take care of your affairs can cost your loved ones plenty. I have a roundtable of legal experts, and we are putting your most pressing questions to them. Thank you all so much for joining the conversation. I appreciate this.
Glad to be here.
My
Sure
pleasure.
Very glad to be here.
Now, this is National Estate Planning Awareness Week, but certainly this is an important issue that we need to discuss at least once a month. And our guests, I want to introduce them to you, are attorney Elizabeth Williams Winfield, attorney Terrence Quinn, and attorney Taisha White. I want to share some facts with you before we get into this conversation. According to a Consumer Reports study, 70% of Black Americans don't have a will. Historically, lower wealth accumulation among Black Americans can lead to the perception that estate planning isn't necessary. Also, according to a report by Cerulli, by 2045, up to $84 trillion will be transferred from households to heirs or donated to charities. And that means a significant source of generational wealth is being missed by Black families. I want to first ask, as it relates to that statistic, and I'll start with you, Elizabeth. Why do you think that so many Black people do not have wills or any form of estate planning?
You know, that's a very interesting question. And as I mentioned, I was in the DC area this past weekend for a National Bar Association function with labor employment section. And that was a question because Attorney Quinn actually moderated two events. And it was a question he asked, and I'm not certain if it was actually answered directly. But in my opinion, and we'll go around, but in my opinion, I think it's emotions. If I make a will, I'm going to die, period. If I think about this, it's going to happen. And, you know, so it just stops a lot of people from putting plans in place that will not only protect their assets while they're alive, but also preserve their legacy for their families. So I think if that question is on a law school exam, my number one answer would be emotions. We don't want to think about it. What do you guys think?
Yeah, Terrence, I was going to ask, so if I don't make a will, that means I'm not going to die, right? I'm going to live forever if I don't put together a will.
I wish it was like that, because we have a lot of probate cases in my law firm where people did not have wills and they definitely died. So you know, if that was the case, that would be a good way to keep it going. One of the things that comes to mind for me, I think that. And by the way, thank you for having me on. I'm thrilled to be here with you. This is an exciting opportunity always to share this information with people. But I think that we're so busy trying to just live life, trying to deal with all of the stuff we have to deal with in life. So, pick the community, but in particular in our community, and it was a National Bar event, which is the Black Bar Association. It's just so much that we're dealing with on a day-to-day basis, from just trying to make a living and make ends meet, trying to work this job and show up at my company and be okay and not lose this job, trying to raise my children and work out this marriage. And it's just so much stuff that we're having. That's not even talking about historical problems that have continued to show up today. All of that stuff happening to us at one time, it can be very easy to put off the stuff that can proactively help us move forward ourselves and present a platform for the next generation to be blessed and prosperous in the future. So I agree with Elizabeth. I do think there are a lot of different reasons why people don't do it, but I think one that's not mentioned often is we're just busy truly trying to make it work where we are. And it's easy to put this off. It's very easy to put it off in the middle of all of that.
Taisha, talk to me about what the risks or even dangers of not having a will can be.
Yep. So I think that actually is probably a third reason that people don't do it, is they just kind of think that they've said it, so that's what's going to be what will happen with the estate. They don't understand that there has to be a court proceeding if they don't create a plan, and that there are a set of default laws in each state that will tell your family how it's going to be split. I do think it's, grandma said I could have the house, and, I've lived here, I've paid all the bills, I took care of grandma, and they think that's how it's going to go. But they don't understand that without a plan in place, the state isn't considering all of those extra things. It's created a plan that's generic for everyone. It cannot consider everybody's situation. And so I don't think they understand the risk of default state laws applying to their estate plan. Yep. So with probate, there's a whole court proceeding. All of your assets will be listed. It'll be published in the newspaper. I know my grandma used to love to read the paper to see obituaries and where funerals are, but there are people that read those things to see what probate has been open and who, which person passed with some money and property, and they will reach out to try to get a stake in that. So I don't think people understand those risks associated with not doing a plan.
What does that mean? They may reach out to get a stake in that.
Yep. So there are these companies that do air searches. And so they'll say, hey, did you know that your aunt so-and-so looks like she died on such and such, and she has a probate opened? And it looks like there might be some money coming to you. Do you want me to pursue that for you? So there's a whole industry of people bringing claims on behalf of found heirs.
That sounds like ambulance chasing for the deceased.
Yeah, pretty much.
Yes.
Yeah. So Elizabeth, where do you start? At what age, number one, should you start? Is it 18, 21, out of college, joining the military? What, when, where, how?
I will tell you, in the state of Georgia, you can make a will at the age of 14.
At 14?
At 14 in the state of Georgia. What I do is I'm a member of Jack and Jill. Okay. So I go to my chapter and I said, listen, when my son graduated, he was 9 of the members, 9 seniors that year. So I'm like, okay, before we send our 9 seniors out, we're going to make sure they have a power of attorney in place and an advance directive. But the power of attorney, God forbid, someone gets into a car accident or anything crazy like that, and they're still living, they're of the age. So you have to have someone in a legal position to be able to continue, manage their affairs, pay their bills, do whatever, file their taxes. You have to have someone in a legal authority in a position to do that. So we can do that with a power of attorney. The next document is an advance directive. So again, somebody's in a car accident, they're in the hospital, you have to have someone with a legal authority to be able to speak to doctors on that person's behalf. So those are 2 documents, right out the bat. Let's get those done for our young people. And then, as we get older, I would suggest to do a will as well. But, let's look at doing a will. Let's look at doing a trust. And this is my group right out of that's graduating from Jack and Jill. Now, we're going to talk about the average individual, maybe single, young adult. Let's look at what you have. And then we can determine if you need a will, if you're going to need a will, but if you need a trust to accompany that will. But at the very minimum, power of attorney, advance directive, and some type of legal instrument such as a will and a trust, or just a will, just depending on the situation.
I mean, gosh, first of all, I'm still thinking about, what did I own at 14? An iPod? I mean, what do you bequeath?
That iPod is important to you. So you may want that iPod to go to your best friend and not to your mom and dad, because they're not going to know what to do with the iPod anyway. So we put that in writing. Because as Taisha said, that if you don't put it in writing, then the lovely state that you live in have an estate plan for you. And it might not be exactly what you want. So at 14, we have this iPod. If God calls me home, I want my iPod to go to my best friend because we share data. We share the same playlist, whatever. And that's who I want to have it. Otherwise, it is going to go to mom and dad. And it's going to be stuck in their drawer for another 40 years.
Yeah, and I'm lying. iPods were not created when I was 14. Maybe my Earth, Wind, and Fire collection. But
can I add a thought to that?
Please do. Go right ahead.
But also consider there could be an interested party, an uncle, an aunt, a grandparent, or something like that didn't plan correctly, but did leave an asset, because most people don't plan correctly, but did leave an asset to that 14-year-old. And maybe the 14-year-old passed after the time that person had left the asset to him. Well, now that asset is going to go through probate court, and maybe the 14-year-old had someone other than just mom and dad, which probably local laws would send it to, where they wanted those assets to go. So there are all types of things that can happen. That does say that the person who's of age, whatever of age means in your state, should have a plan in place. And that plan should definitely include whatever the of age number is. Everybody at that age and older should have at least a will, a financial power of attorney, and a healthcare power of attorney, period. I don't need to know what you own. I don't need to know anything about you. But if you have capacity to do it, because of age and cognitive ability, you should have a will at least, and a financial and a healthcare power of attorney, period. No questions asked.
But Terrence, I did want to ask when it may be most practical, which is not to say that, as Elizabeth said, for example, in the state of Georgia, whether you're 14, 15, etc., but as an adult, at what point should you really, in your opinion, should you start thinking about it? 18? 21, when you buy a house, when you have your first car, when?
Yeah, today you should, whatever your age is. If you're of age, today is the day and today is the age that you should start thinking about it. And please know, I'm not saying this because I'm hoping people call me to hire me. I'm saying this because this is true. If you're an adult, and whatever adult means in your state, it's time to think about it right now. People think that this is only one of the things that people say, hey, I don't have enough. I don't have a whole lot of assets. I don't know if I need enough. Estate planning is about so much more than the assets that you have. Now, the assets that you have, the type and the value, and the to whom you want to send it, does help us as practitioners determine what type of plan you should have. But everybody that's an adult should have at least a basic plan in place that answers two questions. There's two major questions that we all have to deal with. And I think these are two of the four most important questions we all will deal with in one way or another. Number one, what happens to your assets, no matter how much or how little, or your children or family, if you die? So if you don't wake up tomorrow, what would happen to whatever you have, whether it's just a pair of socks or whether it's millions of dollars in assets? What's going to happen to it starting tomorrow? But then number two, if you suddenly could not make decisions for yourself, who would have the power and authority to make financial and medical decisions for you? So those questions don't have an age. As long as you're old enough to be able to make a decision and it count, you're the age that where you should start thinking about it right now. Then talk to the attorney, and it's our job to help you figure out what the plan should look like. It's your job to say, let's start that process now, right now.
Excellent. We're going to take a brief break, but don't forget, you can hear this in every edition of the Daily Drum Insight segment via podcast on WHUR.com. The original Quiet Storm with Raheem Devon is next on WHUR-FM. I'm Harold Fisher. This conversation continues on Sirius XM channel 141 and 96.3 HD2 in just a few seconds. Welcome back to the Daily Drum on Sirius XM channel 141. I'm Harold Fisher. We continue our discussion about estate planning. My guests are attorney Elizabeth Williams Winfield, attorney Terrence Quinn, and attorney Taisha White. I want to talk a little bit about trust versus or trusts and wills. Taisha, what is the difference, and should you have one or the other or both, and why?
Yes. So wills have been the tool that most of our community members know about. What a lot of people don't know is that even with a will, your estate still has to go through probate. So a will is nothing but a letter to the court and frankly the whole world to say, here's all I have and here's who's about to get some money. And that will all be in public filings for people to look up. Okay, so I think that's one thing. There's a myth I think that people think if they had a will, then that will address probate. It won't. A trust is actually a legal entity that we are establishing that can own money and property. So you can put your house in the name of a trust. You can't put your house in the name of a will. Okay, what we're doing with the trust is we're creating essentially a bucket that you can start loading up your assets in so that the moment you pass, it is automatically owned by something else, by another legally recognized entity. And as such, it can do things that a will cannot do. So a will is going to give outright distribution. So let's say, I'm a mother, I had 3 children and I passed when they were all in their 20s. They're each about to get $100,000. If I just have a will, first of all, my 20-something-year-old kids are going to have to deal with a court proceeding, which they're probably not necessarily equipped to do on their own. So they're going to have to hire an attorney that is going to get a fee, right? Likely from whatever they're getting. And then once they get their money as a lump sum, do you want to guess what the first thing is that they're going to buy? A car, which is an asset. Okay. Mm-hmm. So I've worked all my life, providing for these kids, and they're getting it as an outright lump sum that they can do whatever they want, even if it's not wise decisions. With the trust, I can actually put some guidelines as to when they can get money out and for what reason. And essentially I can say, hey, my kids are young, or I don't really know that my family is particularly good with handling money. I can put a trusted person in place called a successor trustee, and then they can take over handling my assets for me. So a trust is useful for many things. So we can avoid probate, we keep all of our information private, and we have more creative options for how and when money and assets are distributed out to other people, so our beneficiaries.
Interesting. Is that, Elizabeth, how someone who establishes a trust for estate planning, can that help avoid the emotional mess that often happens after someone dies?
Absolutely. Absolutely. And as Taisha just mentioned, a will is very public. So everybody, all your information is within this court. A trust, on the other hand, is very private. Did I just say that? Or did I say a trust is private and a will is public? Okay. Just want to make sure I reiterated that correctly.
Right.
So, but it definitely takes the emotions out of it. Most of the time, I want to say 100% of the time, after I meet with the client and we completed their plans, let's say even 90% of them have some type of trust-based plan, they take a deep breath afterwards. Mm-hmm. They feel a sense of accomplishment and they put it away. Really, they don't need to take a look at it again until, hopefully at the end of the year. I always tell my clients is when you're sitting around watching the bowl games, December 31, pull that will out. You're changing your battery and your smoke detector, pull that plan out and let's see what has changed throughout the year. Did our families grow? Did our families downsize? Did our business grow? What changes took place that could affect your plan? So as far as the emotion, it's the emotion is definitely there. But once those plans are in place, it gives everybody a sense of ease, a sense of real. You can almost sit back and just relax at that point because your plan is in place.
Yeah. That when I lost my father and stepmother, we did not have that. But in talking to others and talking about these kinds of issues, it seemed that in some cases my family was in the minority. But even with that being the case, and I'll start with you, Terrence. As an attorney, outside of the legal part, how have you dealt with some of the emotional issues for families when they are trying to put together wills or trusts, or even when they discover that someone is ill and that their time on this earth is limited and they're trying to deal with these issues? Just as an attorney, how do you deal with that kind of stuff?
Yeah, carefully, patient. So I get the privilege of being able to train attorneys around the country. I'll be in Minnesota this coming weekend doing an all-day workshop teaching attorneys how to do this kind of stuff. And so one of the things that I always try to emphasize with attorneys is to be patient and remember that while this might be your 10th, your 100th, your 1,000th or 10,000th client, this is their one mom that they lost, or their one serious health diagnosis that they've received. And so their world has been rocked heavily. And so people respond to grief differently. And you never know. Sometimes the person who was the best, sweetest, nicest, mild-mannered person in the family becomes a bulldog when Big Mama dies. Or the person who was the bulldog all along becomes real reserved and quiet and soft when it happens. And whatever the case, my job is not to come in and just drop some legal stuff on them. My job is to understand what they're dealing with, show empathy, because this is a big deal, and actually care about what's going on. So when I say carefully, I'm very serious when I say that. Having said that, you asked earlier about, does the trust-based plan eliminate the grief or eliminate the chaos that can occur? It is designed to help eliminate the chaos, but at the end of the day, they still lost their mom. At the end of the day, there's still sibling rivalry that's going on among the children. At the end of the day, there's still problems that the people are experiencing. So whatever plan we do, I have to not only come with a lawyer. If I'm in this space, if I'm going to be committed to this space of law, I have to approach it not only with it's in my best interest, I'd say, and the families. If I can approach it not only with legal expertise, but also social, relational, family understanding, knowing that this is a tough spot. We see people, and I'll stop. We see people at their worst. We see them at their best too, when they're doing well and they want to put a plan in place just to take care of business and make sure stuff is tied down well. But we're also the people who get the call when the crisis has hit the house. And so we have to deal with that carefully. We have to pay attention to everything. We have to have some discernment so we can see the person who's really trying to get the stuff, only concerned about getting the stuff by any means necessary. And we have to navigate all of that based on the wishes that the decedent shared with us, and understanding the law at the same time. So we got to approach it carefully.
Tasha, you were nodding your head. Your thoughts about.
Absolutely. So the emotion is going to be there. One of the things that we're trying to do as estate planning attorneys is to, one, hear if there already is some drama brewing. There usually is. It's not usual that it's somebody dies and then all of a sudden everybody loses their mind. Whatever the emotions and the chaos happens, it's been there. So one, we're trying to hear what's happening there. Part of what happens, I think, with the chaos that can happen with the families is that it was not discussed as to what was going to happen. So a lot of people think, well, I should keep quiet the plan, right? Either they don't want to let somebody know that they're being left less than what they think. They don't want to deal with the drama. But having a conversation while the person is still alive, helps. It should help minimize the challenges when they're not here. And I think that that's some of it is just the fear of confrontation, of letting somebody know you ain't getting the house like you thought you were, right? So those conversations are important. And that's something I try to encourage my clients to do is we're not going to make a plan and then just stuff it away and nobody knows about it. There should be some family meetings, when mom dies, when dad dies, we should already know what's going to happen. And I think another way that chaos happens is because people are often trying to do these estate plans on their own, because we all have these apps that tell us we can do it on their own. Mm-hmm. And there are these unintended mistakes, just lack of knowing really what the law is. And now that creates a whole can of worms that somebody thought they wrapped up. So I think it's really important for families to openly communicate what the plan is, and to work with an attorney to work creatively to try to minimize the disputes.
So, Elizabeth, when someone sits down to do a will and or a trust, who else should be in the room where it happens other than you and that person? Should the person that you want to be the executor of the estate be there? Should it be a spouse? Should it just be you and the client? What do you think?
Well, I'm going to say all of the above. We're going to start out with just the client, okay? Because it's that you were establishing that relationship, the attorney-client relationship. Husband and wife, I separate them first. And I ask, do you want your spouse to be in the room? And if so, ask the other spouse. And then I have them to sign a waiver that we can discuss everything in front of each other. So there are no secrets.
That sounds really juicy and unpleasant.
Well, I recently had a situation and it was not pretty. I ended up being a mediator between a new couple, and but nevertheless, we start out that way. So once, let's say if it's a husband and wife, and we are having our conversation, and we go through our process. At the end, if there are children involved, there are adult children involved, if you want to have your administrator, as Taisha said, you definitely want to make sure that the people who need to know about your estate plan. Okay. As far as having a family meeting, I offer to be able to conduct a family meeting. Again, it's a neutral space. We can talk about it, talk about the plan that's already been established. And in that way, when the first spouse passes, there are no surprises. Some take me up on that and some do not. But yes, it can definitely be very emotional when it comes to those types of secrets that, the oldest thought he was going to get the house, or the baby girl thought she was going to get the house, only to find out that I had to read a will, early on in my career. And the family came to me, everyone sitting around the table, and dad actually wrote out one of the children. And that, I thought I was going to have to call the police because it was not a pretty sight. But that was a situation where, it was dad's business and he kept it close to his chest. And when I die, that's when you find out about it. That's not always the best way to handle situations. But
oh my gracious.
Yes.
Well, so with that in mind, Terrence, before they come and sit down with you, what do you recommend that people have in mind? I would imagine some people will come to you and they say, I need a will and or a trust, but I don't know. I mean, they come to you with their arms thrown up, but short of not knowing, I mean, is there a list? What do you recommend that people have in place or in mind before they come and see you?
Yeah, so it depends on the stage, but so first of all, if they're coming just to start the conversation, I don't want them to have anything, because what some people will say, well, I want to get everything together first before I come and see you. I want to figure. No, let's start talking, because the things you're going to get together might not be the things I need you to get together. And the things you don't get together are probably the things I do need. Let's start the conversation. And the process is going to help you determine and discover what you need to bring to the table. Now, with that, what would I love for them to already know and have in place when they first come to see me? They should already know what they own. In order for me to do their estate plan, and let me say this, as an estate planning attorney, our job is to help people acquire, build, protect, and properly leave everything that's a part of their estate. So everything that they own, including themselves and their body, our job is to help them around that. So when they're coming in to see us, what would be ideal is if they've already thought through some of this stuff. I'm the one person in all of my clients' lives that has to know everything about them. I got to know everything they own, all about their family, including the family secrets that Elizabeth was alluding to earlier. I also got to know something about their health. I have to know all of that stuff. I'm the guy who has to know, and I can't share it. There's a confidentiality piece, which also is why we really don't want anybody else in that meeting, at least certain portions of it, because anybody else in that meeting causes the attorney-client privilege to be broken, and we would have to testify. So certain portions of that meeting, we need everybody out of the room. What should they know? They should know what they own. Do they have to know it to the penny? Not for the initial conversation. At some point, we probably should know that, but everything that they own, all of their assets, we need to know that as well. They should consider who would they want to handle decisions for them. If they were alive but couldn't make decisions, who would they want to handle money for them? Who would they want to make medical decisions for them? In addition to that, who they want handling stuff after they're gone? They're going to tell us in that meeting who they want to get everything and how. So they should know that too. But there's somebody who needs to be in charge of making sure that happens when they're gone. They should think that through as well. I don't need them to make a final decision before they come see me, because I'm going to help them figure out if who they thought was the right person in the first place. But they should have a list of people that they would trust to do certain things at that time. And they don't have to be all attorneys and financial people. They can be people who don't have any background in any of those things. But we're going to talk that through. Last thing, I always push my clients to have 3 people in each category. So I encourage them to have a main person, a backup, and then a backup to the backup. Because now I've lived through this situation where a person died. Her daughter was appointed as the trustee. The daughter died. And the second daughter was appointed as the backup trustee, who was my client. And she brought it in and said, "Terrence, can you handle this for me?" I said, "Sure." 2 weeks later, my client got killed in a car accident. And fortunately, the mom had a third person listed who was actually available to serve. So recap, I need to know, it's great if they've thought about who they want in charge in the various categories. Don't make a final decision, but just bring some names to the discussion and know everything that you own: life insurance, investment accounts, property, banking assets, and have some idea of the approximate value of those assets. You bring that to the meeting, we're off to the races.
So I want to go back to something, Taisha, about wills versus trust. It just occurred to me because initially you were talking about assets going into the trust, but for specific instructions after death, you want a Cinderella funeral and all of that stuff is in the will. Is that correct?
So actually, you can put that stuff in a separate document called a memorial memorandum.
Really? Go ahead, do tell.
So oftentimes people will make some statements in their will about it. And to answer your question you asked before, and if you're going to do a trust, you need a will also. You need a will because you could be in a car accident. There could be a medical malpractice lawsuit. So you need the will to say the money that obviously could not be moved to the trust while you're alive, that will is directing that money that could come in after you pass to the trust. So I want to answer that. But yes, I mean, usually the details of a memorial will be in a separate document. Unless somebody has done pre-arrangements. And so you will often see in a will, somebody will say, "I want to be buried at such and such, et cetera." But there's a much more detailed document that my clients get when they do an estate package. They can list everything from songs to who is actually going to be listed in an obituary. I know I've sat at the table a few times where there has been conflict about, are we listing special friends and all of that in the obituary? So yes, you can definitely do that, in a separate document. It's usually not going to be that detailed in either the will or the trust. It should be a separate document.
Man, I should have been an estate attorney. But
it gets wild. It gets wild.
Yeah,
Yes,
It
it
gets
does.
very ugly on the things that are so minor. I want to just add to the question about who should be in the room when you do the plan.
Mm-hmm.
In addition to the points that both Elizabeth and Terrence raised, you as the beneficiary, it's probably not good for you to be in that meeting because other beneficiaries or heirs could say you unduly influence mom or dad. And that is one of the factors, is whether or not a beneficiary was in the room that's going to kind of get the bulk or an unfair amount of the the estate. So for everyone's protection, it is best that only the people that are actually doing the plan be in the room. So if a married couple is planning together, they obviously can both be in the room. Sometimes, like, if I have a client that may not know how to use the technology, so we're doing the call by Zoom, if they have an only child and that's the only heir, so even if there was a challenge to the plan, that child would get it anyway, I might allow that person to be in the room to help with the technology, but I will hush them up. So it should be only the person whose assets are at play should be the one telling the attorney what they want to have happen.
So, Taisha, this sounds expensive. I mean, it really does. I mean, you the will, you got the trust, you got the memorial document, and you've got on the black and white referee's vest and the red flag and the yellow flag and all of that other stuff. How much should someone, let us say someone, and I know it varies from attorney to attorney, mom and pop attorney shop to large firm, I get it. But how much should, if I have an estate that's worth, including my home and everything that I own, that's worth $700,000, and I am in good health and all of that, how much should I expect to pay for this stuff?
Great question, and we get it a lot. I want us as a community to move from being penny wise and pound foolish, okay? So the real question is, how much is it going to cost me to not do a plan, okay?
Look, I get it. Let us say that we are going to do a plan.
Okay. You just want some straight up numbers.
Yeah, I just want, it's not, if I'm 14 and I want to bequeath my G.I. Joe with the Kung Fu grip, that's one thing. Okay. Yep. But, it's completely different.
I don't know. That's worth a lot of money. That's worth a lot of money.
That's right. Especially if it's in the box. If it's in the box. I'm talking about. Yeah, exactly. Yeah. So there you go. But if I started a lemonade stand at 14 and now at 60, I'm running Harold's Lemonade, and my corporation is worth X amount of hundreds of thousands, millions of dollars. But I guess I'm still, people want to know, how much am I going to have to pay to take care of this?
That's fair. And I'm going to give the famous attorney answer of it depends. So estate planning can range from about $1,500 for a uncomplicated, very limited assets planning with a will. And it can range into the several tens of thousands of dollars, because the more you have at stake, there are additional tools that attorneys have that can protect against taxes, creditors, etc. So the more complicated your assets and your family situation, you should likely expect to pay more. So it can range, on average, I would say for relatively simple, you've got a house, a bank account, and no family drama, around $1,500 for a will package, up to $5,000 to $10,000 for a trust package.
Okay. So Elizabeth, Taisha just mentioned something that I think is really important. If you are the beneficiary of an estate, and I know you're in Georgia, and so rules vary from state to state, and this can be for you, Elizabeth, or anybody who can address estate taxes. At what point, what dollar amount, or what kind of possession should someone who is a beneficiary be concerned about paying taxes on what they receive?
So right now, until I think it's December of 2025, if you're inheriting 16 million and under, or the estate is worth 16 million and is worth under 16 million, then we're not worried about estate tax. Okay, it doesn't even apply. Now, after 2025 and it sunsets in terms of the estate tax, I think it's going to go back down to between 5 and 6 million, if I'm not mistaken, in terms of that's the threshold of an estate when we start talking about estate taxes.
You're talking about federal.
That's correct.
Right. So let me make sure I'm clear for our listeners. So if my estate is worth $15 million, just the thought of that, and my beloved daughter, she's going to get a check for $15 million after I die. She would love to hear this conversation. Does that mean so she doesn't have to pay taxes on that $15 million check?
And let me be clear, because we have, just like you said, federal taxes and we have state taxes, and it depends on her situation. But on a federal level, we're looking, the estate, and I wish I knew the number right off the top of my head. I'm looking to get the client that has an estate. I'm sorry.
13.6.
13.61 million for a single person.
There we go.
27.2 million for a married couple.
So 13.61
million for a single person, and
I
27.2 for a married couple.
So if she gets a check for between now and the end of 2025, if I pass away, I have an estate, and I bequeath to her $13 million. She doesn't have to pay federal taxes on that.
That is correct. Well, it depends on the type of asset.
Depends on the asset.
I'm saying cash.
Yeah.
Cash.
So if it's a tax deferred retirement account where she's receiving the money, then she will have to pay taxes on that money she receives from that account. So it depends on the type of asset. So if we're talking about life insurance, real estate that she did not have any ownership interest in ahead of time, bank accounts, for example, brokerage accounts, we're talking about that totals $13 million. And no, she shouldn't have a federal estate tax that's charged against that.
There could be estate tax.
Yeah.
Usually
I think
the state estate tax exemption is lower, just so people know. It's usually much lower.
We could talk about this for another hour, but I know that you all do charge by the hour. And so as a result, we are going to end this conversation right here. But I do want to thank you, Elizabeth, Terrence, and Taisha, for sharing all of this information and really just letting us know how important this is, number one, and number two, that you have to talk to a legal expert, particularly if your estate is complex, and even if it isn't, but certainly if it is complex. So again, thank you all so very, very much. I really appreciate your time.
Thank you.
Thank you.
That is the Daily Drum for this Tuesday, October 22nd. I'm Harold Fisher. Good night.